A Canadian business owner ended up personally on the hook for over $704,000 in GST HST that his corporation collected from customers but never sent to CRA. And the Tax Code of Canada, in a 2026 decision, upheld every dollar of the assessment against him personally. Now, this is a real case, and if you run a corporation, sit as a director, or are involved in any business that collects GST, HST, this decision has something important in it for you. Hi, my name is Amandeep Singh. I'm a CPA and the founder of Cloudiverse CPAs in Burnaby, British Columbia. On this channel, I walk through real CRA disputes and tax code cases so that business owners like you can see how these situations actually develop long before they become $700,000 problems. Today's case is Craig Stevens versus His Majesty the King 2026 Tax Code of Canada case, a publicly available Tax Code of Canada decision. It brings together GST, HST compliance, director responsibility, corporate documentation, and CRA collections all in one story. Now, let me take you through what happened. The company and the center of this case was an Ontario corporation called Wise Buy Home Inc. The business sold refurbished consumer products and appliances. And its best, the company was generating over $8 million a year in revenue. Craig Stevens became the sole shareholder and sole director of the company on March 22, 2011. Now, over the following years, the business started declining financially, unfortunately. Revenue dropped. And in October 2016, the corporation shut down entirely. Now, throughout the years the business was running, between January 2012 and October 2016, the corporation was collecting GST from its customer on every sale. The money was collected. But according to the code, it was kept rather than being sent to CRA as required. By the time the case reached the director liability stage, that accumulated amount alone, including interest, had grown to approximately $704,000. And here's something worth pausing on. The corporation itself had already accepted that debt. So Mr. Stevens himself acknowledged at trial that the corporation had failed to remit. So the tax court was focused on one thing. Could CRA hold Mr. Stevens personally responsible for that debt as a director? Now, under Canadian tax law, specifically subsection 323(1) of the Excise Tax Act, a director of a corporation can become personally liable when the corporation fails to remit GST or HST. But CRA has to go after the corporation first before coming after the director personally. In this case, CRA registered the corporation's debt in federal court in February 2018. A formal collection process was attempted against the corporation. Now, that process came back with nothing recovered, and at that point, the legislation allowed CRA to turn its attention to the director personally. Now, CRA first assessed Mr. Stevens personally in September 2018 for over $1.4 million. And after he objected, CRA reassessed in January 2020 and reduced the amount to approximately $700,000, accepting that this liability only covered the period starting from March 22nd, 2011 and the date he actually became director. That date matters a great deal in these cases. The period someone actually held the director role shapes exactly what they need to be held responsible for. So Mr. Stevens put forward two main defenses, and both of them are worth understanding because they come up regularly in director liability situations. Now, his first defense was this. He argued that he had actually resigned as director back on June 15, 2015, and under the Excise Tax 323(5) section, CRA generally cannot access a director for more than 2 years after that person last stopped being a director. Now, if the court accepted a June 2015 resignation date, the September 2018 assessment would have fallen outside that 2-year window entirely. So the central question became, did he actually step down in June 2015? Because Weisby was an Ontario corporation, the court looked into Ontario's Business Corporations Act to answer that key question. Now, under Ontario corporate law, a resignation becomes effective when the corporation receives the written resignation. That word, receives, became the heart of the issue. The question was whether reliable evidence existed showing the corporation actually received the letter. Mr. Stevens testified that he had hand-delivered a signed resignation letter to a person involved in the company's finances. Now, he said he was stepping away because a consulting opportunity in Saudi Arabia was drawing his attention elsewhere. He also said he left the follow-up filings with that individual to handle. Now, the court examined the evidence very carefully and found very little objective support on that account. The resignation letter came with zero acknowledgement of receipt from the corporation. The company's minute book contained nothing from that time documenting a resignation. You see, government filings reflecting a director change were absent at the relevant time. And the individual, Mr. Stevens, said he delivered the letter to was never brought forward to confirm the account. The timing of the events also influenced the court's assessment significantly. When CRA sent Mr. Stevens a personal warning letter in May 2016 flagging possible director liability, the evidence showed that a clear and immediate reference to an existing resignation letter failed to follow. A second CRA warning arrived in February 2018. The resignation argument still emerged gradually rather than immediately. A notice of objection filed in December 2018 challenged the assessment on general grounds. You see, written representations specifically focused on the resignation only surfaced on September 2019, and the resignation letter itself was only produced in November 2019. The court found that the delay in producing such an important document, one that could have resolved the matter entirely if it existed and had been delivered in 2015, was difficult to reconcile with the account being true. The judge concluded that the oral testimony was neither compelling nor sufficiently corroborated. The court also treated a corporate profile update completed in 2019 as carrying limited weight because it was prepared well after the dispute had already begun. With the resignation unproven, the 2-year limitation protection under subsection 323(5) was unavailable, unfortunately, to Mr. Stevens. His second defense, was what lawyers call the due diligence defense under subsection 323(3) of the Excise Tax Act. This defense is available to a director who can show they took reasonable steps to prevent the corporation from failing to remit GST HST in the first place. And that word, prevent, is where the court spent a lot of its attention. Mr. Stevens argued that he had relied on another individual within the company to handle financial oversight and tax filings. The court found that that reliance on its own fell well short of what the due diligence defense requires. The evidence showed the corporation had no formal system to ensure GST HST remittances were actually going out. There was no dedicated account set up aside for those remittances. The evidence also showed that Mr. Stevens had made no inquiries into whether filings were being completed or whether remittances were being sent throughout those years. The court also noted that the corporation already carried GST HST compliance issues from before Mr. Stevens acquired the shares. Now, this is very important. There was pre-existing CRA debt before his time as a director, and the court found it difficult to accept that someone with a business education, an MBA, practical business experience, and professional legal support during the acquisition process would be unaware of serious tax compliance problems already present in the company he was taking over. You see, the court concluded that meaningful preventative steps had simply been absent throughout the years the corporation was operating. The due diligence defense fell away. The appeal was dismissed, costs were awarded against Mr. Stevens, and the personal assessment of over $704,000 was upheld in full. So, what does this case actually mean for you as a business owner? You see, the first thing the court's findings make clear is that a director resignation needs a complete paper trail, a signed letter supported by an acknowledgement of receipt, a minute book entry, a director register update, and a government filing that lines up with the resignation date. Those things together create a record that holds up years later if CRA ever raises the question. The court's analysis showed that a letter alone, with nothing supporting it, left the entire account open to challenge. The second thing is about GST HST itself. When your business collects GST/HST from customers, that money belongs to CRA. It's trust money. The court's findings in these cases like this show how that exposure can accumulate over the years and unfortunately ultimately land on director personally. And the third thing is about oversight. The due diligence defense is a real protection available to directors, but the court's findings make it clear that it requires active steps, real systems, and documented follow-through. Delegating financial responsibility to someone else with zero oversight structure in place is a risk that can be difficult to defend later in the court. This is exactly where Cloudiverse CPAs comes in. Think of us at Google Maps for your corporate tax position. We show you where you are, flag what is coming, and reroute you before a small compliance gap turns into a six-figure personal tax liability. At Cloudiverse CPAs in Burnaby, we focus on corporate tax, GST, filings, compliance, and documentation that actually holds up when CRA comes looking. Reach out to us. The link is in the description. To wrap up, what the court found in Stevens, the evidence supporting the resignation was found to be insufficient. The 2-year limitation protection was therefore unavailable. The due diligence defense also fell away because meaningful preventative action was absent during the years the corporation was operating, and the personal assessment of over $704,000 was upheld in full. If you found this breakdown useful, please subscribe. We cover real CRA cases and tax decisions that matter to Canadian businesses. And if you have a topic you would like me to cover, drop it in the comments below. Thanks for watching, and I'll see you in my next video. Until then, bye.